Hi, my name is Norshifa Nazifa binti Harisham and my student ID is 0363304. So today I will explain 3 equitable maxims of my choice in this video presentation. So first of all, I will start with the definition and the nature of equity. So equity is the process by which a legal system reconciles the need for accuracy in the rulemaking with the necessity of achieving equality in the particular circumstances. According to the journal article by Lilita, which is according to Nicholas the Sophist's early maxim, exercise a maxim is a general phrase that offers some guidance and advice for something beneficial in life. A maxim is always about the word rather than deeds. In the journal article Duta Swaswata, Sir Henry Maine defined equity as a new body of rules by the opposition of the fundamentals developed on the distinct principles and claimed to override the law by virtue of its superior sanctity that contained in those principles. So of what value then is this maxim for? What reason is there for retaining in the law book? In the journal article, Professor Terry states that it falls within the category of extra-legal principle, which we may refer to as legislative that because they serve as a guidelines to show how the law ought to be made. So the first maxim equity that I choose is equity for the law. So this principle essentially states that equity will usually come to the same conclusion as a common law. So in the journal article where a court finds there is a compelling cause to the contrary, so equity is bound to the common law. In a situation where the law fails to provide this party with appropriate justice, so equity will step in to close the gap. So the origin of this maxim was developed in the 17th century that following the Earls of Oxford case 1615, in which the king decided that equity should only take precedence over the common law in case of disagreement, otherwise equity must follow the law. For historical context was, the first one is the origin in medieval England, second is the growing disagreement between the equity and the common law, and the third one is the case of Earl of Oxford 1615. Next, for the significance of maxim in the development of equity will be shared by Nazifa Solicitor. Hi, my name is Nazifa. I'm a solicitor from the Nazham company. I will briefly explain about the significant maxim, which is equity follows the law. So the first one is maintain the legal explicitness, where the maxim prevents the judge from granting the relief based on the personal fairness alone, which is ensuring equity that stays consistent with the legal rights and statute. So the strength in this maxim is this maxim prevents the judge from using the equity to change the law. So the authority of the parliament and the stability of the legal system depends on this restriction. So the weaknesses is it may prevent equity from achieving the fairness. Second weakness is it can make it unclear when equity should step in. Since Nazifa Solicitor already explained about the strengths and weaknesses, so I will elaborate on the case law. There are 6 case law. So the first case law is the Earls of Oxford case 1615, which is the foundational case. So this is the maxim primary authority. According to the King James, equity takes precedence over the common law where there is a clear contradiction. However, equity will still need to follow the law, which this case proves that equity corrects rather than supersedes the law. The second case is Walls and Lonsdale's 1982, which is equals rights are seen as a legal rights. According to the court, a lease agreement that is enforceable in equity must be regarded as tort, which is were a legitimate lease, which is this demonstrated as a legal principles are applied to equitable's interest in equity. The next case law is Tinsley and Milligan. Equity cannot take a precedence over the unlawful conduct. So the House of Lords decide that the common law notions of illegality cannot be overcome by a claimant using equitable theories such as trust. So in here demonstrate that fairness cannot conflict with the public policy and must adhere to the legal prohibition. For Malaysian cases, according to the case Robert Lee and Woh Ai Yap, which this case is a direct application of the maxim because when a statute is clear, equity must comply with it and cannot create a right inconsistent with the legal framework. In the case of Kwok Pen Seng and Robert Doran, so the case demonstrates that equitable doctrine have a limited role in torrents jurisdiction, where a certain and indefensibles of title are paramount. So judicial interpretations of the maxim equity follows the law. The first one is a legal right must be exercised in equity. According to the how court interpret the maxim, equity cannot take precedence over established legal principles or statutory right. The second one is equity corrects the law, not replaced it. So judges has repeatedly insisted that equity is an additional in the law and only step in when the law is insufficient. And the third one is applying the legal principles to equitable's right. So rather than establishing a distant system, equity ties itself with the law by applying the legal principles to equitable rights. For the modern application, here is a clear and modern practical applications of the maxim equity follows the law with a real-life example. So the first one is statutory registration system are acknowledged by equity. So legal title is held by the registered proprietor in land registration system, such as in Malaysia. For example, dispute regarding a registered property, where a resident that is brought registered solely in person B name is contributed to person by person A. Despite its apparent unfairness, equity will, instead of working against the law, equity will work around it. The second example is conjuncture, which is influencer contract on social media. An influencer orally promised a management a share of revenue but later refused. Equity cannot enforce uncertain agreement or those violation employment law. It is only applies if a constructive trust arises and cannot override the contract or statutory rules. And the third one is modern trust and property law. Conflict that over the co-ownership property are common. The scenario is a couple live in a home registered to one partner, so the other contribute the mortgage and uncapped. So the non-owner partners may claim a beneficial interest under the constructive trust, recognized only within Clause 1996. So the court balances the statutory law within fairness. So the second maxim that I choose is he who comes to equity must come with a clean hand. So the definition is a claimant whose action may be deemed improper will not be granted equitable remedy. In the case of Rowans and Dunn, explained that this maxim can't be used to stop a claimant from enforcing his equitable entitlement to property rather than it's only applied when discretion's remedy is requested. So the origin of this maxim, according to the journal article, which is according to the Pomeroy, the concept of underlying this maxim is merely the articulations of one of the central ideas of equity jurisprudence. Pomeroy argues that any time it's related to the matter that aren't strictly governed by the law, sanctuary has the power to force a defendant to follow their conscience. So, history context. The first one is sanctuary practice in the Middle Age and early, and the second one is combining following the Judicature Act of 1873 until 1875. Moving on to the developments of equity. So the clean hand theory made sure that litigants could not utilize equity to profit from wrongdoer. Equitable remedies were only available to those who act morally. And the court upheld its integrity by declining to support a claimant whose own behavior was sold. According to the case law, during an Earl of Winchelsea held that performing improper entails the acting improperly in a legal sense rather than morally. Second case is Ugly and Arkley. Therefore, equity will not deny the claimant's relief just because the claimant's overall behavior is inadequate. Next case is Cosworth and Johnson, which is demonstrate that clean hand in relation to the contracts are necessary for equitable remedies like a specific performance. In the case of Cheng Chuan Development Sdn Bhd and Ng Ah Hock, the principle of this case, which is it emphasized that the claimant's misconduct must related to the subject matter of the dispute. Next case is Mucklestone Browns, where both parties have unclean hand. So the case provides a clear examples of the fundamental principles that equity would not assist a wrongdoer, particularly when accomplishing thus would allow the party to benefit from unlawful behavior. And for where a claimant does not need to rely on his unclean hand to prove his claim, which is in the case of the maxim does not apply in the case of Tinsley and Milligan, which is contrast with the Fusing Construction Berhad and Eon Finance Berhad, where the court didn't recognize the existence of the alleged trust, thus the party claiming its existence has to rely on its own dirty hands. So next is judicial interpretations of this maxim. The first one is equity is not a court of morality. So the court refrained from prosecuting ordinary immorality. which is this illustrates how the Maxim has been narrowed in the recent time. So, second one is remaining the essential to discretionary therapies. Because he violated the list that he was trying to enforce, so the claimant in the case of Cosworth and Johnson 1886 was not granted particular performance. So the maxim is utilized by the court to prevent abuse of Equitable's remedy. Next is the strength of this maxim, which is to ensure the equity, morals integrity, and the fairness, to prevent claim from profiting from their own misconduct, and also to prevent dishonest or fraudulent behavior from being enforced through the legal system. The weaknesses and criticisms is it's applied too widely in the past, which enabling the judge to refuse reliefs of the basics of their own moral judgment, and also can occasionally produce an unfair outcome if enforced strictly. So here are the realistic modern day examples. The first one is injunction case, where a social media misconduct situation. For someone who makes unfounded accusations about another person off the internet, afterwards where they request an injunction to prevent the other party from replying or disseminating the screenshot. Applying the maxim, since the applicant spread of false materials in the bad faith, the court is likely to reject the injunction. So equity will not shade someone who abused the very platform where they seek protection from. Second one is commercial contract, which is the negotiation in a bad faith, where a company requests a particular performance of a supply contract from the court, but however there is a proof that the company intentionally gave a fraudulent financial statement when negotiation. So applying the maxim is because the claimant dishonest impact the contract itself, the court declined the specific performance. So equity will not enforce a contract obtained by a deceptive behavior. And the third one is family property conflict, where the situation of hiding asset, where a spouse petitions for an equitable portion of the family property after concealing the marital asset abroad. So applying this maxim, because of the claimant act dishonest in the things that related to the dispute, the court may reject Equitable's relief. So the last maxim that I choose is equality is equity. So according to the journal articles, the idea behind the Equitable's maxim, which is equality is equity, appears to be an equality that equity are similar due to some unspoken desire. So the maxim and the principles are indistinguishable. So the origin of this maxim addresses the inflexibility of a common law is where the maxim is first appeared. So when justice required a balance, the early century practice of allocating the cost and benefit equal was summed up in the expression equality is equity. The historical context where early century practice 15th and 17th century, where the chancellor frequently split property or right equal when the co-ownerships or the beneficiary had conflict interest, unless there was a proof of the contrary. This was particularly crucial for joint tenancy, which is joint tenancy, partnerships asset, trust, and estate inheritance. Next is significance develops of equity. So although the maxim has proved importance in determining the respective interests of a married couples in the family home, its general significance in the law of trust has been questioned because it was really aligned with the intentions of the person who creates the trust. Moving on to the strengths of the maxim, which is encourage the equal distribution that is consistent and fair, prohibits parties with a comparable right from being treated arbitrarily. Next is criticisms of the maxim. So in situation where contributions vary much, equality may be artificial or unfair. So it could be at odds with a clear agreement or a contradictory intent. So the case law that related in this maxim is the first one is Baruch v. Cos 1840, which is equality is the most equitable course of action when a court is unable to identify any justification of an unequal distribution. Second case is Rowe and Price 1999, where the case serves as examples of contemporary equitable reasoning, where equal shares become the default when behavior indicates the joint ownership, but evidence of proportions is ambiguous. The third case is Tai Kwang Gao Miss and Yap Koi Hee 1995, where equity demands that members of the same class be treated equally, particularly in the case of receiverships or insolvency. Next is judicial interpretations. According to the court interpretations, the maxim means is equals division unless intention indicates otherwise. In joint venture, partnerships, marital property, and co-ownership, court assume equal shares until there is evidence to the contrary. Second is equality cover both advantage and disadvantage. So parties that share ownership equally also share liabilities, costs, and losses. So court places a strong focus on proportionality, so equity appropriately allocates both burdens and also the benefit. And the third one is court can differ from equality since it tends to be inflexibility. So judge emphasized that the maxim is not unqualified. This adaptability demonstrates that the maxim offers a direction rather than a rigid guideline. And fourth is the relation to the law of insolvency. If positions are insufficient, so the court employ pari passu distribution, which divides the creditors equally. So this arises from the claimant's equitable dedications of justice. Next is modern applications of maxim equality is equity. So the first one is property co-ownerships. Unless otherwise demonstrate that equity assumes equality when individuals purchase a real estate together but fail to indicate a share. So modern scenario, when two friends buy a house together but they make an equal mortgage payment but do not sign a trust deed. So the court will probably use equality is equity and divide it as 50-50 if there is a disagreement about the selling proceed. So why this reflect the maxim? So there is no clear evidence of a different intention. Fairness require an equal treatment where contributions and conduct are similar. The second case is share asset and joint bank account. Unless there is a proof to the contrary, so the court frequently assume equal beneficial ownership when the two people jointly own a bank account and make about equals contribution. For a modern examples, where a couple who have been together jointly own a fixed deposit, since both parties consider the account shared, equity may distribute the money evenly when the relationships ends. Third is divisions of matrimonial asset under family law. So the court frequently takes an equality-inspired stance, where especially when both partners make distinct but equally significant contribution to the marriage. Modern example, even if the other spouse paid the mortgage, a spouse who stay at the home and raise the children may be granted a 50% part in the marital residence. Why this reflect to the maxim? It is because equity acknowledge non-monetary contribution, so the contribution of both spouses must be valued equally in order to be fair. Fourth is business collaboration. Equity may split profit and liability equally when partners invest in a corporation without defining ownerships and percentage. The modern application is a technology business is founded by the three engineers, but they neglect to draft a partnerships agreement. So the court allocate earning and obligations equal if there is no proof of unequal contribution. In conclusion, when combined, these three maxims show how equity strikes a crucial balance between morality, justice, and legal certainty. So the maxim equality follows the law, ensure equity respects the legal rules and common law authority. So he who comes to the equity must come with clean hands, require a claimant to act fairly. Equality is equity is reflect the equity aim to achieve the just outcome when the legal rights are unclear. So when taken as a whole, this maxim demonstrates that equality is an additional system intended to address injustice, preserve justice, and support moral norms while still adhering the law. So here is my bibliography. So the second page is also bibliography. So that's all from me. Thank you.